It's a common misconception that patent or prior art searching is a required or even a standard part of the patent process. The reality is that actually very few cases have patent searching done on them. I would say 95, 98% of the cases that I work on never have any patent searching done on them at all. So this is top 5 reasons why you don't actually need a patent search. Number 5, hidden prior art. So in the patent application process during examination, although the examiner has access to all sorts of prior art, which can include issued patents and patent publications, the vast majority of the time, the only prior art that's cited against a patent application is going to be published application or issued patents. So by default, applications are held in secret for 18 months and can potentially be secret all the way up until they issue. So some of the most relevant prior art that could be potentially used against your patent application could be hidden. It could be hidden for at least 18 months. It could be hidden all the way up until the patent issues. So you're going to have a huge blind side when it comes to doing patent prior art searching, especially when it comes to fast-moving fields. The most relevant stuff may be completely hidden to you. Number 4, the patent examination process is extremely subjective. So when you file a patent application, it gets assigned to a patent examiner at the USPTO. And every patent examiner is very different, and the way that they examine patent applications can be totally different. You get one examiner for your invention, and he'll say, oh yeah, this is totally allowable, there's nothing like it, and you would get it assigned to another examiner, and that examiner would say, nope, there's stuff that's totally the same, this is obvious, and you're going to get very different treatment depending on the examiner that you get. So when you do a prior art search, you're not going to get a lot of information that's going to be helpful to the subjective nature of the examination process. Sure, you can get a general sense of what the prior art may be, but you're not going to get a very good sense of how any given examiner is going to interpret it. One examiner may interpret it as, this is fine, this is not relevant, and another may say, this makes your idea unpatentable. So given the subjective nature of the patent process, doing a prior art search doesn't really help you get the information that you want. That being, is my invention patentable or not, and how broad of a patent am I going to be able to get if I file my patent application. Number 3. Patents are a gradient. So it's a common misconception that patents are binary. That is, you have a patent or you don't, and all patents are created equal. That if you have an issued patent, you have an issued patent. And if you don't have one, you don't have one. The reality is that patents are gradients, and by that I mean they can be really broad or they can be really narrow. Broad patents cover a lot of different variations. That being, if somebody tries to come in and copy what you're doing, they can't just make small changes and get around your patent. A broad patent is going to cover a lot of variations, so that it's really difficult for people to do anything similar to your invention and not infringe. On the other hand, you can have a really, really narrow patent. Sure, you get a patent issued, but it's so narrow and so specific and only covers one very specific thing that an infringer could come in and make some small, little, tiny tweak to your invention and get around your patent. So the reality is that the question of, is my idea patentable or is it not, it's really not the right question to ask. A lot of times, sure, something is going to be patentable, right? You're going to be able to have such a narrow, specific patent that's kind of worthless, but that's not really going to help you. What you really want to ask is, how broad or narrow is my patent going to be? But as we talked about in the last in the last number, it's so subjective between examiner to examiner. So the reality is you're not going to be able to get the information that you want. You're not going to be able to know, is my patent going to be broad or narrow? And a lot of times, even is it patentable or not, that's not going to, you're not going to be able to get that answer as well. Number 2, cart before the horse. So a lot of folks want to have a patent search done when they're in very early stages of development of a product. And they want to know whether that general idea of something is going to be patentable. Now, the problem with doing a patent search at this stage is that you really aren't going to get the information that you want. Broad ideas typically aren't going to be patentable. It's going to have to do with a specific implementation. So unless you know what your specific implementation is already going to be, or the specific method that you're going to perform when doing a computer method, or the specific way of manufacturing something, you're not going to be able to get a very good prior art search done. The information you're going to get, it's going to be too broad, too high level, and you're really not going to know one way or another whether what your broad idea is, whether that will be patentable or not. This is especially true with folks who start with a provisional patent application, have a year to develop the product, and then file the non-provisional application a year from then, and then the non-provisional application is actually examined. So a lot can change in that year. A lot of times what happens with these folks is the really important things, the big inventions, the things that ultimately make the product patentable, those happen during that year of R&D after filing an initial provisional application. Also, the idea can totally pivot, and I see that all the time. The idea that starts out as one thing, it pivots to a totally different thing, and that new thing may be totally patentable compared to what they started out with. So people with kernels of ideas or ideas that aren't fully fleshed out don't do themselves a service by doing an early prior art search. It doesn't really give very relevant results, and it may exclude a business that will ultimately get to something that is very, very patentable and that is going to be very, very worthwhile and useful. And number one, it's just not worth the cost. So we've talked about the limitations that prior art searches have. One is that there's a lot of hidden prior out there. You could be blind to 18 months worth of really relevant prior art, and even longer than that, given that some prior art doesn't even come up until the patent issues. Also, the subjective nature of the patent process. Every examiner is going to look at things differently, and doing a prior art search isn't really going to help you given the subjective nature of things. Also, because you want to think about patents being broad or narrow, doing a prior art search doesn't really give you information as to whether the patent is going to be broad or narrow in the end. You don't know until you actually get into examination. And also, at early stages, when people want information about whether something's going to be patentable or not, they're not going to be able to get good information, because a lot of times the idea or the invention is at such an early stage that doing a prior art search on that isn't going to be very relevant. So the hundreds of dollars, most likely the thousands of dollars you'll spend on prior art searching or prior art analysis isn't going to be worth it. That money is far better spent on just filing an initial provisional patent application or on R&D. There are a lot of other things that money can be better spent on. A lot of times I see search firms and even some patent attorneys, unfortunately, kind of prey on folks and their fears and upsell them and incur extra needless cost by doing prior art searches. So it's just typically not worth the cost. So that is top 5 reasons why you don't actually need a patent search. Let me know what you think about the video. Do you agree? Do you disagree? Did I miss something? Let me know in the comments down below. I'd love to hear from you. If you thought this video was valuable, give it a big old thumbs up and consider subscribing to the channel. Now, I'm going to have some videos popping up here. We've got a lot of other good content on the channel, including a video about why you might actually need a patent search. Now, admittedly, there are some times when you might actually want a patent search. It's very rare, but they do occur sometimes. So check out that video as well. Look forward to hearing from you in the comments down below, and we will see you in the next video. Cheers.